And it's a pleasure to be with you all today. Today is Friday, and you know what that means. If it's the first Friday of the month, then I'm on. Who am I? Well, it says it right here. Michael Cord, Esquire, attorney at law. And I guess that's centered there. And I'm here to talk to you about the law. And today is going to be a special show. Well, let me be clear. Every show is a special show, but this one will be especially special. Why? Because it's timely and it gets into exactly what you should know about the law. And what you should know about the law is how it really works. It's not just a matter of what the law says, but more important, it's what the law does. So let me start from the beginning. The reason why I'm talking about this is, as you know, about a week or so ago, yeah, a little over a week ago, something happened that was historic. When I say historic, I truly mean historic. For the first time in American history, since this country was founded in 1776, and since the US Constitution went into effect in 1789, a former president of the United States of America was indicted on criminal charges. When I say criminal charges, I mean criminal charges of the sort that you would never imagine in the United States of America. Mafia type crimes. And I want to be clear, that's not hyperbole. That's not an overstatement. That's not an exaggeration. When I say a mafia type crime, I mean that. So if you're looking at me right now, you will see over my left shoulder is an image of Malcolm X. And for me, that's important when it comes to me talking about the law, because Brother Malcolm always made it clear when he said, make it plain. So he's whispering in my ear right now and saying, hey, Brother Michael X, we know that you think you're some big time fancy lawyer. You know all these convoluted and complex legal terms and jargon. We don't need to do that today. We want to make it plain. So Brother Malcolm told me to explain what happened in that Donald Dump case and apply it to how it goes for the average person in the so-called criminal justice system. And if you're talking about the average person in the so-called criminal justice system, and by the way, I say so-called because there's no justice in the system. I heard a wise man once say it's not a criminal justice system, not even a so-called criminal justice system. What it is a criminal punishment system. It creates certain rules to punish people. And we'll get into the details about that in just a second. But let me start with the background. And the background goes like this. Back in 2018, 5 years ago, I decided, correction, the ancestors decided to have me teach and have me teach the law and have me explain the law in a way that's easy to understand. So the ancestors told me back in 2018 to create something called an online law school, and they called it the Nat Turner Law School. So every time I come on TV or every time I come on radio and talk about the law, it's me doing a lecture from the online Nat Turner Law School. And for those of you who don't know who Nat Turner is, you got to find out. Suffice it to say, back on August 21, 1831, a black man decided that he wasn't going to take it anymore. He wasn't going to take it anymore for himself. He wasn't going to take it anymore for his people. So he rose up and he took justifiable action. I'm not going to say that it was violence, because it wasn't violence. If you look at the legal definition of violence, or even the dictionary definition of violence, it says an unwarranted use of force, an unjustified use of force. So you can be a violent man or a violent woman or a violent boy or a violent girl or a violent other. If somebody breaks into your house and is trying to kill your family members and you run into the kitchen and you grab a knife and you stab that intruder to death while he is trying to kill your mother or father, that's not violence. Because remember, violence is the unwarranted use of force, the unjustified use of force. So if it's not violence to use a knife to repel an intruder who broke into your house, who's trying to kill your mother and father, then it wasn't violence when Nat Turner decided to rise up against the most brutal system in the history of humankind, American slavery. So in honor of Nat Turner, I call this school the Nat Turner Law School. And every time I do a lecture, I call it that thing, whatever that thing is, 101. So today we're going to deal with the Nat Turner Law School, the criminal justice, even better, the criminal punishment system 101. So it's the Nat Turner Law School and it's the criminal punishment system 101 lecture. And it's great for me to talk about it today because it's timely. Remember, I told you just recently, former fake President Donald Trump, who I call the Mango Mussolini or the Orange Hitler, he did something that should have put him in prison as soon as he did it. But in America, there's something called due process. And because of due process, which by the way is a great thing, he has to have his day in court. So I want to tell you what happened in his situation and then apply that to the average criminal defendant in America's criminal punishment system. Here's the background. Former fake President Donald Trump decided that he and his gang of 18 other conspirators would overthrow American democracy by taking away the right to vote of people in Georgia. Let me repeat that so you can see the context, what this whole thing is about. And I want you to follow me from the very beginning to the end of this lecture that's going to wrap up in approximately 50 minutes. So that's 50 minutes. So it goes like this. Back on August 24, the former fake president had to surrender himself for booking. Now follow me, August 24. This was in connection with what happened 10 days earlier on August 14, when the grand jury results were made public. In other words, the grand jury decision was, the legal term is unsealed. So on August 14, the grand jury indictment was unsealed. 10 days later, on August 24, former fake President Donald Trump, a few others, and a couple of days before and a couple of days after, all 19 surrendered themselves for the booking process. So what I'm going to explain about his situation and what I'm going to explain about how the system generally works is kind of sort of two different things, but quite similar. So again, Brother Malcolm is telling me to make it plain. That's exactly what I'm going to do. Make it plain. And it goes like this. What happened with those 19, Donald Trump and the 18 others, is that a great prosecutor, a great district attorney by the name of Fani Willis, and I want to respect her by giving you her entire name, Fani Taifa Willis. Many people don't know this, but this prominent and preeminent prosecutor, this prominent and preeminent district attorney, is the daughter of a former Black Panther. Think about that. You might assume that the son or daughter of a former Black Panther would be a defense attorney, and that's a fair assumption. But it's a stroke of genius on the part of Sister Fani Taifa Willis and her father and her mother to say that, hey, you should be on the side of the people who normally oppress us so you can be a check on that oppression. Yeah, you can put the bad guys in jail, but you can make sure that everybody is presumed innocent as they're supposed to be. You can make sure that there's no racial oppression, and you can make sure that there is no prosecutorial misconduct. So the genius of the father of Fannie Taifa Willis, and who was a former Black Panther, along with her mother, the two of them raising her right, sending her to college, sending her to law school. She served as a assistant district attorney. She served as a judge, and now she's the duly elected district attorney of Fulton County, which includes Atlanta, all in Georgia. So what she said is this: hey, when former fake president, and let me make sure I describe him right. We're not talking about the former fake president. We're talking about the twice impeached, 4 times indicted, sexually assaulting, adjudicated former president. Think about that. No other president, and I got to tell you, I mean, I'm no fan of American history. Pretty much they're all racist. But there's only one who was twice impeached, only one who was indicted 4 times, only one who was adjudicated for being a sexual assaulter, and that's Donald Trump. And I guess I should call him Donald Trump because that's his family name. His family's from Germany, and the name is actually spelled Drumpf, Trump. But when his father came to America, he wanted to anglicize it and make it sound more quote unquote American. And that's why they changed it from Trump to Trump. But I'm going to go back to Trump for obvious reasons. So what the district attorney of Fulton County said is that, hey, we got evidence that you called up the Secretary of State of the state of Georgia and you said, hey, I need about 11,000 votes to win Georgia. And if I win Georgia, I can ultimately win the United States. Who does that? And it was even more. He sent his emissaries to try to influence and intimidate the people of Georgia. It gets even worse. One woman, the only Black woman among the 19 who used to work for Kanye West, I guess just like he's crazy, she's also crazy. And she tried to bully, intimidate, frighten, and cajole a Black woman who had done her job as an election worker. And this former employee of Kanye West was trying to get the woman to confess to a crime that the woman didn't commit. So you got this Black woman, quote unquote, allegedly Black woman, who used to work for crazy Kanye West, who then became a member of Blacks for Trump. Who does that? What Black person in his right mind would support a proven racist? Look at it this way. When I say proven racist, that's not hyperbole. What I'm saying is this. When Donald Trump first ran for president, he was endorsed by David Duke. Who is David Duke? David Duke was the Grand Dragon of the KKK. So the same presidential candidate who's endorsed by the former Grand Dragon of the KKK, that candidate has a group called Blacks for Trump. Who does that? Crazy people, self-hating people do that. And that's not the end of it. In addition to being endorsed by the former Grand Dragon of the KKK, that same guy called the Nazis good people. What president who calls the Nazis good people would have a group called Blacks for that guy? Blacks for the guy who's endorsed by the KKK. Blacks for the guy who said the Nazis are good people. You want more? I got more. That same president, fake president, is the one who sent racist white men on January 6th into the US Capitol waving the Confederate flag. You know what the Confederate flag is about. That was the South trying to keep slavery, to keep Black people down. So the same guy who supports the enslavement of Black people through the Confederate flag while violently taking over the US Capitol, that guy has a group called Blacks for Trump. I want to curse and say, what the F is wrong with these people? But I want everybody to watch this. So I don't want to don't want to say anything that's so profane that it can't be aired during daytime hours. So I just say, what the heck is wrong with these Black people? But I digress. Let me get back to the point. So you got this racist guy, Donald Trump, endorsed by the KKK, calling the Nazis good people and sending Confederate flag waving racists into the Capitol. That guy has a group called Blacks for Trump. And one member, two members actually, but one right now I'm talking about one, the Black woman, is one of the 19 conspirators as part of Trump's political mafia gang. She's one of the 19 who's been charged because she tried to bully, intimidate, and coerce a Black woman who did her job. There was a Black woman and her daughter. They were election day workers. They were counting the ballots as required. They were legally and lawfully handling all the documents. And despite that, this former employee of Kanye West, this Black woman who's part of Blacks for Trump, tried to force and intimidate that woman into confessing about doing something illegal with the ballots. Fortunately, that Black woman wasn't stupid and refused to agree. But based on that, by the Trump supporter, that Black woman, the other Black woman, is one of the 19. So you might say, well, okay, what are they charged with? Well, on average, most of them are charged with like 15 and 20 different crimes. But essentially, the main crime is a violation of the RICO law. And the RICO law is a federal law, but it's also similarly applied to most, if not all, the states. And what is RICO? RICO is RICO, Racketeering, Influence, and Corrupt Organizations Act. Racketeering, Influence, and Corrupt Organizations Act. What does that mean? That means that in 1972, the federal government said, hey, we know there's this gang out here, this organized crime gang out here called the Mafia, but it's so hard for us to catch them because the person in charge, the Godfather, he makes sure that what he does, he doesn't have any blood on his hands personally. He won't go out and kill people. He won't go out and assault people. He won't go out and rob and burglarize and shake down people himself. He's on the top, he controls it. But he'll send his soldiers, his lieutenants, his assistants out there to do it. So what they came up with in 1972 was ingenious. Here's what it said. It said, in addition to criminalizing bad behavior, we're going to criminalize bad organizations. So the crime is not just shooting somebody. The crime is being part of an organized gang that basically, traditionally, often shoot, rob, rape, pillage, whatever. So the crime is being in the group, in addition to the crime being doing the thing. So it's a crime to be in the mafia. It's a crime to be in the Bloods. It's a crime to be in the Crips. It's a crime to be a part of any corrupt organization. So what Fannie Willis did in Fulton County as a DA, she took that RICO type law and said, hey, these 19 people were part of a corrupt organization. And as part of this corrupt organization, they were trying to violate people's basic, fundamental, legal, constitutional rights, the right to vote and the right to have your vote counted. So based on that, the Honorable Fannie Taifa Willis charged all 19 with racketeering, as part of a criminal enterprise to use fraud to overturn the 2020 presidential election in Georgia. Let me repeat that. She strategically, in a 98-page indictment, charged those 19 defendants headed by Donald Trump with racketeering as part of a criminal enterprise to use fraud to overturn the 2020 presidential election in the state of Florida. That's the underlying crime. So what she did was reached out to a grand jury, approximately 21 citizens from Fulton County who heard the allegations. And after those, approximately 21 different states have different numbers, but it's always more than the standard 12 jurors for a regular jury. So it's approximately 21. So these 21 citizens heard the evidence that the DA presented. And based on what they heard, they had two choices. One, they could say no bill, or two, they could say true bill. No bill means that, hey, it's not enough evidence here. I don't see anything. You can't charge these people. Or they can say a true bill, which means, hey, what I heard was pretty serious and these people should be charged. The way people can be charged with crimes generally is one of two ways: by an indictment or by an information. An indictment is done through a grand jury. Something called an information is just a piece of paper that the DA pulls out of his or her desk and says, hey, Joe Blow should be charged with murder based on the evidence. But in order for District Attorney Fannie Willis of Fulton County, she said, hey, I don't want people to say that I did this on my own. I want the public. I want Republicans. I want Democrats. I want independents. I want voters. I want non-voters. I want them to be in a grand jury. I want them to hear the allegations, and I want them to determine whether or not these people should be charged with crimes. And that grand jury said, yeah, they should be charged with crimes. And I got to tell you, most grand jury indictments might be about 15, maybe 20 pages. This was damn near 100 pages. It was 98 pages of strong evidence, so strong, and quote me on this right now, so strong that I'm willing to bet anybody that of those 19, I'd say 5 or more are going to flip and testify against the others. Quote me on that now. If I'm wrong, I'll come back and say I was wrong. But right now, I believe at least 5 and maybe more, at least 5 or more of the 19 defendants will decide to plead guilty for either probation or plead guilty for a short jail sentence in exchange for testifying against the others. And when I say at least 5 or more, I really mean that, because several of them are already complaining that they are not being provided with the money they need for quality legal representation. You can bet that Donald Trump got some of the top lawyers in Georgia. You can bet that Rudy Giuliani got some of the top lawyers in Georgia, but some of the other people, like that black woman, like the black man. In fact, let me tell you about the black man for a second. There are 19 defendants in this case. And of the 19 defendants, 2 are black. And of the 2 black, 1 is a man. Now, let me back up and ask you a question. Of those 19 who went through the booking process, only 1 is still in jail. The rest of them were processed in as short as 20 minutes for Donald Trump and maybe about 30 minutes, 35 for the others. But of that 19, only 1 has not been released like the other 18. And remember, I told you there's 1 black man among all these 19 defendants. Try to guess which one of the 19 is still in jail. You're right, the black guy. The 1 black guy among the 19 persons, among the 18 white persons, the 1 black guy is still in jail because he cannot afford to pay bail. His stupid behind was out there trying to get black people to vote for the same man who now has him in jail, who's not paying for his legal representation and is not paying for his bail. That's why I say at least 5 of those 19 are going to flip, are going to plead guilty, are going to get a good deal, and are going to testify against the more serious ones. Now, having said that, let me tell you about a book that I read years ago, and I just started rereading it because when I wrote an article recently in the Philadelphia Tribune about this thing, about this Donald Trump organized crime gang, I wanted to use some quotes from a legal scholar that would explain the situation of racism in the criminal punishment system better than I ever could. There's a book that was written back in 1987, and the title of the book is Black Robes, White Justice. Black Robes, White Justice. And this 1987 book was written by former New York Supreme Court Justice Bruce Wright. And Bruce Wright, the Honorable Bruce Wright, was a New York Supreme Court Justice for about 11 years from 1983 until 1994. And if you haven't heard of him, please find out more about him. But the best way I can describe him is he's a combination of, let's say, Brother Malcolm X and Thurgood Marshall. So if you got Malcolm X, the fiery revolutionary, and got the Honorable Thurgood Marshall, who, by the way, is the only Black man to ever be on the U.S. Supreme Court. I meant what I just said. Thurgood Marshall is the only Black man who has ever been on the Supreme Court. I know you think they were 2, but you're wrong. So if you take somebody like the fiery revolutionary Malcolm X and the intellectual legal scholar Thurgood Marshall, and you put them together, you have New York Supreme Court Justice Bruce Wright. He got into a lot of trouble as a judge because he condemned racism. When he noticed that the cop was lying on some Black defendant, he would call it out. So he did, as a Black judge, what all Black judges should do, what all white woke judges should do. But many of them are cowards. He's a hero. Here's what he wrote in his book entitled Black Robes, White Justice. He said, quote, "Racism inside the courts is but a reflection of what goes on in society in general. Most of the judges of America are male, white, middle class, aloof, and conservative. Brought before them is a parade of dark-skinned defendants. Judges are the assembly line feeders of the prison system. America's courts, where color should be irrelevant, have been little different from other segments of the nation's life. Color is more than an idle statistic. It is an enduring reality. It is America's way of life." So that judge called it like he saw it. He understood how the system really works. He's right there as part of it, but he tried to destroy it from within. And in the same way he tried to destroy it from within, as you should try to destroy any evil system, I tried to explain it from within. I've been an attorney for about 27, 28 years, and I never decided to become a lawyer to be part of the system. I decided to become a lawyer to destroy the system. I figured I could do more damage on the inside than I could on the outside. So again, in the same way that the Honorable New York Supreme Court Justice Bruce Wright decided to destroy the system from the inside, I'm trying to explain and destroy the system from the inside. So I just told you about the 19 defendants, including former fake President Donald Trump. Told you about the crazy Black woman who was also charged for trying to intimidate another Black woman. into lying about that other black woman doing something illegal, but that other black woman did nothing illegal. She was doing her job. In fact, one of those 19 defendants, Rudy Giuliani, accused that other black woman, the ballot worker, and that other black woman's daughter, another ballot worker. Rudy Giuliani accused them of committing a crime by stealing votes and by being drug dealers in the process. You can't make this stuff up. And that black woman, that ballot worker, her daughter, another ballot worker, were very smart. They got a lawyer. They sued Rudy Giuliani for defamation. Defamation means you say something false and negative about somebody to destroy their reputation. What could be worse in terms of reputation than being accused of being a thief, being accused of being a voting thief, being accused of being a voting thief who's also a drug dealer? So when these two women sued Rudy Giuliani, they won. He didn't even defend himself because he couldn't get around it. He basically admitted, yeah, what I said was wrong. It was a lie and I shouldn't have done it. And the only question now in the case, and the judge just ruled a couple of days ago that, yeah, Rudy Giuliani, the personal lawyer of former fake president Donald Trump, that Rudy did defame these women. So the only question now is, how much will they get? They're going to get paid. They're going to get paid a lot of money. But my point is, you look at what Rudy did to that mother and that daughter who were ballot workers, poll workers, and then you got another dump supporter, a black woman, who goes in to try to intimidate these black women. I got to tell you, something clearly wrong with that. So anyway, that's the background. So you got 19 defendants. You got Donald Trump as the lead defendant. Of those 19, you got 2 blacks, and those 2 blacks are part of a group called Blacks for Trump. And one of those 2 blacks is a man. And the only person among those 19 who didn't make bail, who's still sitting in jail, who doesn't have his own high-powered attorney, is that black guy. As my grandmother used to say, you're going to learn today. And damn it, that black man, I hope he going to learn today and realize that those racists who make up MAGA, those racists who are the base of Donald Trump's voting bloc, not only do they dislike black people, they despise black people. And many of them want to even bring slavery back. That's why they were parading around the US Capitol with a Confederate flag. The Confederacy stands for slavery. So those same people want to enslave you, and your dumbass is part of the same organization that wants to do that to you. The same organization whose leader, Donald Trump, was endorsed by the Grand Dragon of the KKK, whose leader said that Nazis are good people, whose leader is supported by the Proud Boys. I got to tell you, I don't want anybody who doesn't deserve it to be in jail, and I especially don't want a black man to be in jail. But the good thing about this guy who's part of Blacks for Trump, I hope it teaches him a lesson. I hope it slaps him in the face. I hope it brings him back to our black family. Having said that, the time now is 4:03, which means we're through about half of the show. And this is perfect timing, because the first half of the show, I want to talk about that political mafia gang headed by Donald Trump and how he got through the booking process in 20 minutes, how the other 17 white people got through the booking process in about 20, 25 minutes, how the one black woman got through the process in about 30, 35 minutes, and how the one black man never got through it. He's still there. Let's put that to the side for now. Why? Because that procedure is different from how most cases proceed. That was done by a grand jury. And because it was a grand jury, there was no preliminary hearing. I'm going to tell you the difference between a preliminary hearing and a grand jury indictment in just a second. And what I'm about to explain to you is what happens in most of the states throughout the United States, and what happens definitely and specifically here in Pennsylvania, and of course, here in Philadelphia. So if you're arrested here in Pennsylvania, if you're arrested here in Philadelphia, the 11 steps I'm about to tell you as part of my Nat Turner Law School Criminal Procedure One-on-One lecture, folks, get your pens out and get your pads out, or get your iPads, or get your iPhones, or get your laptops, and document what I'm going to say, because it literally could save your life. So here we go within the next 21, 22 minutes. The first step in the process is the arrest. What's an arrest? Well, yeah, if the cops grab you, handcuff you, you're arrested. Grab you, throw you in a police car, you're arrested. Clearly, that's an arrest. But actually, an arrest happens even before that. The legal definition of an arrest is this: anytime you reasonably believe you're not free to leave, you're under arrest. Let me repeat that. But Malcolm said, make it plain. Anytime you're confronted by a police officer, and as a result, you reasonably believe you're not free to leave, you're under arrest. So if a cop comes running down the street and you're standing on the corner and he stops 5-10 feet away from you, he looks at you and puts his hand on his gun, what does that tell you? That tells you you're probably not free to leave. Now, why is it important to know when you are arrested? The reason why it's important to know when you are arrested, because that's when your rights kick in. For example, the right to privacy. And as part of the right to privacy is that the police can't search you without probable cause. They can't invade your space, your private stuff, without probable cause. And without getting too complicated, there's something called reasonable suspicion and probable cause. But in order to arrest you, they have to have reasonable suspicion. So for example, if while I'm doing this show, the cops think that I have drugs in my briefcase next to me, for whatever reason, they think that, they can't just kick in my door, run in here, knock me down, open up my briefcase and see if I got drugs. But let's say they do that. Let's say they find that drugs are in my briefcase. Okay, they can charge me, but then I can file a suppression motion because that was an illegal search and seizure. They had no probable cause. They should have never arrested me. And of course, they kicked in the door and came in here. Then I clearly don't feel like I'm free to leave. And once I feel like reasonably feel like I'm not free to leave, that's when I'm under arrest. And it's when I'm under arrest that my rights kick in. My Fourth Amendment rights against unreasonable search and seizure. You can't kick in my door without probable cause. That's illegal. You can't search my briefcase without probable cause. That's illegal. So I'm going to talk more about probable cause and reasonable suspicion later when we get to pretrial motions. But right now, of those 11 steps as part of the criminal procedure one-on-one, step number 1 is that you first have to be arrested. Step number 2 is the booking and processing step. What you saw in that Fulton County case with Mango Mussolini, AKA Orange Hitler, what you saw there was actually a booking. And a booking is basically, it's technically known as a processing. What happens at a booking? We talked about what happened in that case in Atlanta with the grand jury, which led to the booking, but that booking and processing part also happens as the second step of what goes on right here in Pennsylvania, or what goes on right here in Philadelphia. And basically what the booking, or better stated, processing is, it's a procedure whereby you are fingerprinted, photographed, and have bail set. Fingerprinted, photographed, and have bail set. But I want to be clear. I put that bail part in there because that's what happened in that Georgia case, in that Fulton County case. But in Pennsylvania, it's a little different. In Pennsylvania, the bail part is later. It's not part of this second part. This second part is simply the booking. And another term for the booking is processing. And 2 things happen at that stage. 1, you're fingerprinted. 2, you are photographed. And since you're at the police station going through that, there's going to be a lot of downtime, a lot of downtime. So for several hours, you're probably just going to be sitting at the police station. And during that several hours, at some point, before the fingerprinting, before the photographing, or after, the police are going to try to get you to say something, try to get you to talk. In other words, they're going to try to interrogate you. And I could spend 3 hours, 5 hours, 10 hours explaining to you why you should not participate in any police interrogation. But instead of spending all that time, let me just break it down in about 30 seconds. You've all seen those shows on TV, cop shows, Law and Order and all that kind of stuff. You've seen those movies. And you notice that every time the cops arrest somebody, the first thing the cops will say is this: you have the right to remain silent. Anything you say can and will be used against you. And there's more stuff they say. In fact, in Philadelphia, they actually have this little form. And the form has a list of questions. Number one, do you understand you have the right to remain silent? Number two, do you understand that anything you say can and will be used against you? I'm not going to waste your time to read the next ones. Why? Because they're irrelevant. Why? Think about it. If a cop just arrested you, and the second thing he said to you, or the second thing she said to you, or the second thing they said to you was, quote, anything you say can and will be used against you, unquote. Let me repeat that and drink out of my red, black, and green cup for dramatic effect. The cop just told you, as part of the interrogation, that anything you say can and will be used against you. The cop didn't say that anything you say can or will be used for you. The cop said anything you say can and will be used against you. So if anything you say will be used against you, damn it, why would you say anything? Why would you say anything? Even if you think you're completely innocent. If you say, for example, that wasn't my gun, but now you're admitting that you know about the gun. And if it was somebody else in the car, now you've tied yourself to the person that was in your car who did have the gun. If you say, well, I didn't shoot the guy. Well, now you know about the crime. How do you know the guy was shot? He could have been stabbed. He could have been beaten. How do you know it was a guy? How do you know where it happened? How do you know when it happened? So don't say anything. Often when I'm in court with my client and the cop gets on the stand, my client is nudging me, Mr. Court, the cop is lying, the cop is lying. He's twisting my words. And I slowly turn around and say, but you shouldn't have given him any words to twist. Don't start nothing, it won't be nothing. And there was a time when cops could get away with beating a confession out of you, but that's not so frequent anymore, not because the cops are better people, they're not. In some cases, they're worse. But the system has improved such that the way the system works now, you almost always have to see a lawyer or court staffer or somebody within about 2, 3, 4, 5 hours of your arrest. So if the cops beat the slop out of you, busted your lip, fractured your nose, blackened your eyes, let's say at 8:00 p.m., now you're going to have your preliminary arraignment in front of a bail commissioner or in front of a judge about 5 hours later or about 10 hours later. And even if it's 24 hours later, your nose is still fractured. Your lip is still busted. Your eye is still blackened. And if somebody can see that, whatever statement the cops claim you gave, it's clear that you gave the statement because it was beaten out of you. So instead of the cops beating it out of you now, they try to trick you out of it. But remember, even the trickery won't work if you understand the English language. The cop will say about 8 different things to you regarding your rights, 7 actually. The first one, do you understand you have the right to remain silent? Yes. Number 2, do you understand that anything you say can and will be used against you? Yes. Stop right there. Stop right there. Why would you say anything else? The cop just told you whatever you say will be used against you. Don't say you did it. Don't say you didn't do it. Don't say you were there. Don't say you weren't there. Don't say you know about it. Don't say you don't know about it. Don't say anything. If you forget anything else I said today, remember that. Sit down, shut up, and say nothing. I was in court today with the young man. I was so happy because when I went to visit him in the jail yesterday, and we had our preliminary hearing today, the first thing I asked him when I met with him yesterday, I said, please tell me that you didn't make a statement. He said, Mr. Cord, the only statement I made was talk to my lawyer. I gave him the fist bump and said, you're a smart young man. So his only statement when the cops tried to interrogate him, his only statement was talk to my lawyer, talk to my lawyer. That was fine. That was not only fine, it was perfect. So again, we covered the arrest. That's the first step. And then we covered the booking / processing. That's the fingerprinting and photographing. And around that time might be the interrogation. We just finished that. The third step in the process is the preliminary arraignment. And that's scheduled for that political mafia gang headed by former fake president, twice impeached, 4 times indicted, once adjudicated as a sexual assaulter, the guy we're calling Mango Mussolini, the guy we're calling Orange Hitler, the guy whose father called him Donald Trump. That guy right there, he and his gang are scheduled to have their preliminary arraignment in about a week or two, based on the most recent news reports. But in Pennsylvania, in Philadelphia, that happens relatively quickly. What I mean is this: first you get arrested, and then you are processing books. And when I say it's relatively quickly, I mean it's not a matter of weeks, like this preliminary arraignment in this Fulton County case. Let's say, for example, you get arrested in Philadelphia, it's 8 p.m. You'll probably have your booking / processing anywhere from, let's say, 6 to 8 hours later, because once you're taken to the station, you just sit in the cell, just waiting and waiting and waiting. That could be about 6 hours, 8 hours, even 10 hours. You're just sitting there. And then finally go through the booking and processing. That booking and processing, which is simply the fingerprinting and the photographing, takes a matter of minutes. That's it. But it's the hurry up and wait before that. It's the hurry up and wait after that takes such a long time. And then you go back to the cell, you could sit there for another 6 hours or 8 hours or 10 hours or 12 hours, or maybe even 24 hours. And at the end of that point, you have your preliminary arraignment. And 3 things happen at the preliminary arraignment. They used to be held in City Hall. Then they used to be held in the so-called criminal justice system. Now I know there's the stout criminal justice system, but now they have a system whereby it's done through closed circuit TV. So all the police stations, police districts have the closed circuit TV, where at the police station, you'll stand in front of a TV monitor, and at the so-called stout criminal justice center at 1301 Filbert, there's a bail commissioner, and the bail commissioner sits there as a sort of judge. And 3 things happen during that televised preliminary arraignment. 1, you are formally notified of the charges against you. 2, your preliminary hearing date is scheduled. And 3, your bail is set. You get bail for any charge except first-degree murder and second-degree murder. So if it's third-degree murder on down, if it's robbery, assault, theft, like that, you are eligible for bail. Remember, those 3 things happen at the preliminary arraignment. We're at the 3rd step in the process, and we're going to have to speed this up because time is quickly leaving us. So in the 3rd step, preliminary arraignment, you are informed of the charges, you have a preliminary hearing scheduled, and you have your bail set. The 4th step in the process is the preliminary hearing. The preliminary hearing in Philadelphia, preliminary hearing in Pennsylvania, the outcome is similar to the grand jury indictment. The grand jury will hear the evidence and say, yes, there's enough evidence for a trial, or no, there's not enough evidence to hold a trial. A preliminary hearing serves that same purpose. Without getting too highfalutin and convoluted, a judge will hear the evidence from the police, from the DA's office, and usually it's a police officer as a witness, and the judge, after hearing it, has to decide 2 things. 1, is there any evidence of a crime? 2, Is there any evidence that this defendant committed that crime? As long as the judge says yes, remember I didn't say strong evidence beyond a reasonable doubt. I said any evidence. That's a very low and minimal burden at the preliminary hearing. We lawyers call it prima facie. Prima facie means first face. Prima facie means what does it look like? And so if the judge thinks that it looks like a crime was committed, it looks like this defendant did it, what happens, the judge will say that now the case is going to be held for trial, which in other words, it's going to go from the preliminary hearing to the trial. There's some other stuff that I could tell you about. We don't have time, and it's really not that important for our purposes. But that's step number 4. Step number 5 is the formal arraignment. Formal arraignment is where you formally enter a plea of guilty or not guilty. And at that time, or shortly before or shortly after, you get discovery. What's discovery? Anytime a crime is alleged, the police go out and they discover information through police reports or witness statements or medical records or videos or whatever. And all that stuff that they got, that they discovered throughout the investigation, is called discovery. And copies of all that discovery have to be given to the defendant through the defendant's lawyer. So the thing that happens at a formal arraignment, generally speaking, is you're supposed to enter a plea of guilty or not guilty, but they automatically assume you're going to say not guilty, and then the discovery issue is determined. That's essentially it for the formal arraignment. It's a 30-second process. That's the 4th step in the process. The 5th step in the process is something called the pretrial conference. That's usually at least 60 to 90 days after the formal arraignment, because now, during the past 30 days, the prosecution has given, even before that, prosecution has given the defense attorney the discovery. Now that attorney has 30 days from the day he, she, or they received that discovery to file any motions. You might see here where your client gave a confession, and you might think that that confession was forced out of him. So you want to file a suppression motion, a statement suppression motion. Or you might find out the discovery that the cops kicked in the door to your client's house and searched for a gun and found it in the basement, but the cops didn't have a search warrant. Anything that you think that the judge needs to know about before the trial, that's why they call it a pretrial conference. Once you review that discovery and you see some flaws in the prosecution's case, you file your pretrial motions, and then you go in for a pretrial conference, at which time you argue all that stuff. If you win, case is over. If you don't win, it proceeds. And it proceeds with the 7th step. 7th step is a scheduling conference. And that's exactly what it is. Judge will say, hey, I'm available to try this case on January 19th. Prosecutor, are you available that day? Prosecutor will say, well, Your Honor, I'm going to be in the middle of a jury trial. How's January 23? Judge will say, Mr. Cord, or whoever the defense attorney is, how's January 23 for you? I might say, well, Judge, I'm going to be out of town on a preliminary hearing in Cumberland County. Judge might say, okay, let's move it to February. How's February 2nd for everybody? Everybody agree that February 2nd is cool. Perfect. We all agree February 2nd. That's the date that is provided and announced at the scheduling conference. That's number 7. Number 8 is the trial. And I got to tell you about the trial. The trial is not about the truth. It never has been. Trial is not about the truth. Trial is about process. Trial is about the system. Trial is about the rules. So even if the person did it, but the cops don't have the proper evidence to prove it, the person got to be found not guilty. Best example, O.J. Simpson case. I truly believe that O.J. did it. Why? And I know black people got mad at me, but the truth is like, O.J. had the means, the motive, and the opportunity. Means, motive, opportunity. All those arguments people had about, well, the DNA didn't match. It didn't match because some dumb cops allowed the DNA samples to stay in an SUV overnight. They got overheated, so it was flawed. Officer Furman, yeah, he used the N-word. He's a racist, but he could be a racist and OJ could be guilty. And then people tried to make the argument that OJ couldn't have done it because the glove didn't fit. That's the dumbest thing I could ever heard of. First of all, the glove was made out of leather. The killer stabbed up people and got the blood onto the glove. In fact, it was a blood-soaked glove. If the glove is leather and it was soaked in blood, and inside blood is water and salt, what does water and salt do to leather? It shrinks it. So when the DA foolishly had OJ put on the glove and it didn't fit, and Johnny Cochran jumped all over that and said, If it doesn't fit, you must acquit. But what should have happened is you should have never had OJ to try to put it on because the glove already shrunk. What you should have done is to find a cop who was the approximate height and weight and the same hand size or similar of OJ at the police station through videotape, have that cop put the glove on, and then record that videotape presentation and bring that to the courtroom. So my point is, OJ did it. He had the means, motive, and opportunity. But if I was on the jury, I would have found him not guilty. Why? Because it's not about whether the person did it. It's about whether the prosecution can prove the case beyond a reasonable doubt. And if there are flaws in their case, if they didn't follow the rules, if I was on the jury, we would have been part of the jury. And the first thing we all would have said in the back is, how many people think OJ did it? I would have raised my hand. And the question would have been, how many think he's guilty? Let me back up. I want to say it clearly. Question would have been among the 12 jurors, how many people in the room think OJ did it? I would have raised my hand. Then the question, how many people think he's not guilty? I'd have raised my hand. It'd be like, well, how can you say he did it, but he's not guilty? The answer is this. The judge didn't tell us jurors that we have to go back and determine whether a defendant is guilty or innocent. The judge said we got to decide whether he's guilty or not guilty. Remember, it's not a question of guilty or innocent. It's a question of guilty or not guilty. Innocent means he didn't do it. He doesn't have to prove that. Not guilty means the prosecution didn't prove it. That's trial number 8. Number 9 is sentencing. That speaks for itself. You get the punishment. Number 10, a direct appeal. That's when you go to a higher court. And finally, something called a PCRA, the Post-Conviction Relief Act. You can try to get a different judge using Court of Common Pleas to look at it. Those are the 11 steps. If people have any questions about anything I shared today, contact me at michaelcoard@gmail.com. michaelcoard@gmail.com, and say, hey, Michael X, I didn't get everything you said. Can you send me that article that includes all this information? I'll be honored. michaelcoard@gmail.com. I really appreciate you all taking the time to be with us, taking the time to listen to me, and taking the time to take notes, because you need to empower yourselves against this racist, classist, sexist, criminal punishment system. Thank you all very much. Have a wonderful day.